Good morning, everybody. Welcome to the First District. We have three cases that have been consolidated for argument today. State versus Guyton, State versus O'Neill, and State versus Mosley. Judge Myers is unavailable today, but she will be watching the video, the arguments on YouTube, and participating in the decisions. So we have, these cases are consolidated for argument with 30 minutes per side, and we're going to allow both sides rebuttal time. Ms. Gieske, how much time did you want for rebuttal?
I'll reserve 10 minutes, please.
10 minutes. And the state?
The same, Your Honor.
10 minutes. Okay. And you two are dividing argument? Yes. Will you keep your time? Do you want me to keep your time?
However you prefer. I don't anticipate we're going to use the entire amount. So,
Okay. Okay. Well, you'll have 20 minutes total, and then you'll have your rebuttal time, and I'll keep the green light means go, obviously, and then yellow when you've got a minute left before, and then red when we get to the end of your initial time, then you'll have your rebuttal time. Make sense? Okay. Ms. Gieske, would you like to lead off?
Will it please the court, opposing counsel? As you know, the Reagan-Tokes Law went into effect in March of 2019. And I will just very briefly explain. The enactment provides for indefinite sentences for qualifying F1s and F2s. Per the law, the court imposes a minimum term from within the established statutory range and then a maximum term consisting of 50% of that minimum term. After the inmate serves the minimum term, it is rebuttably presumed that they will be released. And ODRC may rebut that presumption in favor of release at internal administrative proceedings. So we submit that the Reagan-Tokes Law violates numerous constitutional doctrines or provisions: separation of powers, equal protection, substantive due process, and procedural due process. And I would like to begin with separation of powers. So the doctrine of separation of powers, as you know, holds that the three branches of government have defined powers, and one branch may not encroach upon, interfere with, or exercise powers vested in another. Determinations of guilt and punishment are powers vested solely in the judiciary. Only a neutral and detached magistrate may deprive someone of life, liberty, or property. So the crux of our argument here is that the Reagan-Tokes Law unconstitutionally delegates this power, this judicial function, to the executive branch, which is ODRC. Even though...
But how is that the case if the judge actually sets the sentence range, the minimum and the maximum? Like, is the logical extension of your argument that there could be no indefinite sentencing regardless of the structure?
I don't know if I would want to go to the extreme of saying never. However, in this enactment versus the bad time law from the 1990s, even though in name the trial court imposes the maximum term, it is really ODRC that wields the power, that makes the actual decision. So,
Ma'am, isn't that just like our parole procedures that have been in place for years? Doesn't the ODC use those procedures to determine whether somebody ought to be on parole or post-release control?
actually, my answer to that will straddle separation of powers and due process. Because I know that at least, I believe the 12th District in Guyton likened this to parole and maybe PRC as well. And the three are quite different. The similarities lie in the fact that ODRC does have a hand in making the decision internally. And then with post-release control and supervising ODRC, or I guess the parole board supervises the individual. But that's where the similarities end. In particular, for one, with parole is only available to a very unique, the most heinous crimes, the life tail crimes. That is a unique set of offenses, a unique structure, and should be so confined. Also, parole versus Reagan-Tokes. Reagan-Tokes contemplates conduct in prison. parole, particularly parole, there's parole eligibility proceedings and parole revocation proceedings. Even those two are very different. The revocation proceedings, where someone's liberty is taken away, offer a lot more process, exponentially more process than the Reagan-Tokes law. And I'm going to file a supplemental authority, the ODRC policies that were enacted, well, I don't know if you use that word, in Delaval too, the 8th District discussed this policies and rules and
Right,
where they fall.
you're talking about the policy that was discussed in the 8th District?
Yes.
Okay.
Yes. And I think really that's where a lot of the courts of appeals that have addressed this, which is only about half so far. And you know, the eighth was very splintered en banc decision that ended up finding it constitutional. But the Delaval decision is the only one that even really mentions the substance of that policy. I'll call it policy 15, and I will file it.
Let me ask you, ma'am, are we permitted to consider that policy? Is that question before us right now?
I think that you kind of have to. It would behoove the defense almost if you didn't, because if you look at Reagan-Tokes as it stands without the policy, this is again due process really, there's no process. The notice provisions reference, I think it's the parole notice statute, which says that if you're going to have this extension hearing, they call it an additional term hearing in the policy, you only notify the victim, the judge, and the prosecutor. There isn't even any notice statutorily. So you need the policy to supplement the gaps in the Reagan-Tokes law itself. Otherwise, it can't really pass.
But so this is bleeding over into procedural due
It is.
process.
It is.
So before we go there, anything else on separation of powers?
Separation of powers, it is a very simple argument. Either you can say, we're going to view this language on its face and say that, okay, the executive branch maintaining is not the same as imposing sentence. You can end your analysis there. I think that elevates form over function, that really it's ODRC that makes the extension. That's really the beginning and ending of separation of powers. I think that the heart of this does lie in due process, particularly procedural. So to continue the answer with comparing it to post-release control or parole, policy 15 in particular, let me get my notes on it because it's extensive. As far as notice, policy 15 is the Reagan-Tokes additional term hearing. Then it's policy 9, that's the parole and post-release control revocation. Those provide the most process. Under Reagan-Tokes, I can go through that quickly because that hearing, it's very minimal. I would argue that this policy is not due process by any means, even if you do consider it. The inmate gets 30-day written notice. That's it. Okay, fine. As far as the opportunity to be heard, the inmate gets to be there unless the parole board hearing officer, the chair decides for good cause shown that their presence is inappropriate or unwarranted, so they may not get to even be there.
With the notice to the inmate, does that include a notice of the basis that DRC is wishing to extend the term?
It does not, which is one distinction between this and parole revocation. Is here, it says that the parole, so it's not super clear, but when they talk about the parole board hearing chair, when they talk about things that happen before the hearing, they use the phrase parole board hearing chair, or I think designee. Then they start talking about hearing officer. So they say that.
Yeah, I was confused on that. Who is actually presiding at this hearing?
It's a hearing officer, or I think designee. That we don't know who it's going to be. We know that versus parole, it's one person, versus the parole board, which takes action by a majority. So that's another distinction. Here, the inmate, it seems to say during the hearing, because it says the officer will inform them of the reason for holding the hearing. So they don't get to find out till right when they get there. During the hearing, they can provide mitigating information, the inmate, and then the policy even says they can briefly explain. So not a defense, not their own information, just not their own substantive information, just mitigating, briefly explain, that's all you get. And that really is the end of it. After the hearing, the officer determines whether the presumption has been rebutted. And then if it has, and this is an important distinction, that's the Reagan-Tokes subpart C hearing. The subpart D is deciding how long to keep them. That part's not subject to any hearing, nothing like that.
And is there any limit on the discretion in making that decision by DRC?
So the policy says that if the hearing officer decides that they can get in one-day increments up to 365 days, if they want to hold them beyond that, it goes to the chief hearing officer, who uses an additional term, hearing grid, that I could not find for anything in print. So I don't know what that grid entails. What it's still the most important thing is.
Yeah, and again, apologies, but I'm so confused on that. Is there a further hearing, or is that just, I have to send a note to my supervisor?
No, that's behind closed doors. That was my other big point, is it's one person or then one second person behind closed doors. They don't even have to say on the record afterward or anywhere. It just says that the final decision has to be noted in the minutes. That's it. I think we decided to hold you, period. No explanation, nothing. And then the policy does say that that decision is final and non-appealable. So when you compare that to the most process is parole or post-release control revocation, there's something called violation of notice forms that are served on the offender. At that time, the officer determines whether the offender is going to contest those charges. At the time of service, the offender gets to identify witnesses, documents they want to subpoena, the nature of the information they're going to present, and the names and addresses of any witnesses. The offender is also asked to name their private attorney, or if they want representation to be appointed, to let them know they want public representation from our office. Then that required documentation must be provided to counsel prior to the revocation hearing. At the revocation hearing, there are detailed, very detailed processes and procedures for the hearing officer to go through. There's a pre-guilt phase, a guilt phase, a post-guilt phase. It's very, very, very detailed. But most important for our purposes, this is why it's comparing apples to oranges when you try to say that Reagan's-Hoeks is just like parole or post-release control. At this revocation hearing, they can call witnesses, they can cross-examine witnesses, they can put documents into evidence, they can offer testimony. There's a litany of protections. The hearing officer must then state on the record the reasons for imposing any sanction or revoking parole or post-release control. And then the results of that are reviewed by the chief hearing officer, and then those are subject to modification by the parole board. So there's lots of, quote, appeals or oversight.
And so let's say you have a client that goes through this process and says, like, this was not legitimate process. I should not have had my term extended. Obviously, there's no judicial review of this mechanism. Is there any relief for that person at that point?
That's one of our chief arguments, is there's not.
Couldn't they file habeas?
I suppose they could, but the problem with habeas is, as you know, it's a civil attack, so they have no right to counsel. They're going to be you've seen a lot of things filed by pro se inmates. They often don't know what they're talking. They can't. You can't distill 3 years of law school and decades of experience into that person's brain. So they're not going to be able to make viable arguments. It's hard enough for us attorneys to wrap our heads around these constitutional arguments. So habeas is not really a fitting challenge, and it's probably not ever going to work.
Let me ask you a question about notice. And I know you were referring to a specific notice of the violation for this procedure, but it's my understanding at the time of sentence, the judge advises the defendant that there's this potential that you'll do this tail if you essentially don't behave in prison. Then when you're received at the prison, they also go over it once again with you. I'm getting to the point of the question. The procedures you just went through, how do they run afoul of the U.S. Supreme Court's Morrissey, which my reading of is you're entitled to notice in a hearing?
But the Morrissey decision, Morrissey is the reason for all these additional protections provided with the post-release control and parole revocation.
But you're saying they're insufficient under Morrissey, though?
The ones in Reagan's-Hoeks are. Under Policy 9, which is the post-release control, even Policy 3, which is parole eligibility, there's less process than parole revocation, but there's still much more than Reagan's-Hoeks. It's our argument that Reagan's-Hoeks doesn't survive the Morrissey analysis, but these other policies do because of all these additional protections. There's additional notice, not for the eligibility hearing, but much more for the revocation, but there's much more procedure. That's why those survive Morrissey. That's why Reagan's-Hoeks does not.
Well, maybe another threshold question, building off Judge Winkler's question, is what is your position as to what the legal standard is? Because we've got Morrissey, we've got Matthews versus Eldridge, we've got Judge Gwynn's description in his dissent from the 5th District of Wolf. I mean, there's a number of different standards. They're all kind of similar, but like, how should we analyze this?
Such as constitutional review.
Right.
So the simplest way, if I were your law clerk, I would say Matthew v. Eldridge's seminal case, notice and an opportunity to be heard, and that the other companion idea is that the opportunity to be heard has to be meaningful. I don't even think we need to resort to Morrissey. It depends. If you want to liken this to parole and post-release control, you kind of can't avoid going through the protections that Morrissey placed on those and the reason it held those procedures constitutional. If you say they're apples and oranges, you can just do a straight due process analysis based upon Matthew v. Eldridge, and you can keep it that simple, I believe. Really, the notice, even if you do that, the notice is deficient, even if we back up from the other procedures and policies. The notice is deficient on two grounds. Number one, it doesn't adequately notify the inmate of which infractions, and this ties upon not a void for vagueness. I don't want to kind of blur those lines, but there are, I think I cited in my brief, 61 rule infractions alone that can result in maintaining the inmate's term, and then there's, quote, any violation of the law. So pretty much it's anything, or seemingly anything, and that is runs afoul of the constitutional notice. There needs to be more specificity. The other problem is that the Reagan-Tokes provisions, as I touched upon before, don't actually provide that the inmate needs to be notified in advance of anything, just that we're going to have this hearing in a month, the end.
Where is the provision about the 30 days notice?
The 30 days is in the policy. It's in Policy 15, which I'll file.
Yeah, right.
It's not in the Reagan-Tokes law.
I've got that in front of me.
Oh, okay.
That was my question, is where in that policy is the 30-day provision?
It's not. The only time you see the word notice in the Reagan-Tokes law is when they cite the statutory, I don't write the statute down on my outline, but it's the statute that governs parole, and that's the one that provides notice to the prosecutor, the judge, and the victim.
Right. So my question is, where is the provision that provides notice to the inmate?
Other than the policy, there's none.
Okay.
Well, I'm looking at it. It looks like it's under Section E2, D, E2D.
Are you citing the policy, Judge, or
I'm looking at Ohio Administrative Code 5120-906.
And we would argue that to the extent that it provides this, there's 30-day written notice. Unlike the parole, the revocation proceedings, like I think Judge Bergeron, your question touched upon, is the inmate, there's no requirement the inmate's provided with notice of actually what he's being, for lack of a better word, charged with. So, in order to marshal your own defense, marshal your own evidence, you need to know what you're being accused of. And that is not provided for.
Well, it sounds like Franz Kafka, the trial. So you're saying that you show up and you have no idea why you're there.
Yeah, basically, yes.
But then if someone said, hey, you're here for this, then I would raise my hand and say, oh, I'd like that 30-day continuance. Is that insufficient notice to the individual?
In a trial, perhaps not, but there's no the inmate has nowhere near any right like that. They have no control over the proceedings whatsoever.
I thought there was a right to a 30-day continuance, or if you ask for a continuance.
I did not see that.
Okay, I'll have to look then.
Sorry, I did not see that, Judge.
Let me ask you this, ma'am. If we were to consider this policy, doesn't that cut against your argument or your client's argument? Because when I read the statute, my recollection is it says you get a hearing. It doesn't say anything about notice, doesn't say anything else. But if we were to consider this and find it comports with procedural due process, wouldn't that cut against your argument here?
I don't think so, Judge. And I think you have to consider the policy because the statute has so many holes without it. If you do consider the policy, though, and again, if you compare it to, and I don't know if you have these other ones in front of you, but
I found the right one.
The other ones are policies. 9 governs parole and post-release control revocation, and then 3 governs parole eligibility. And then there's also policy 8, which governs discretionary post-release control imposition. So I was going to maybe file the additional ones in if you would like. When you compare all of those other creatures, which some of these courts of appeals have pointed to it to analogize Reagan-Tokes to uphold its constitutionality, well, those decisions don't do this comparative analysis for these policies. The policies are actually what are embodying the procedures that do afford due process. When you compare those policies to Reagan-Tokes Policy 15, it is far deficient. It doesn't provide anywhere near the process. If it did, my argument today would be much harder, but it doesn't.
Well, so maybe that's another question. Like, if this policy provided all the bells and whistles of due process, even though it's not in the statute, it's not in a rule that's promulgated in accordance with the Administrative Procedures Act, would that suffice?
I've thought of that too, and I think it would be, my procedural due process argument would be almost dead in the water. Because I would have to rely more upon the separation of powers, because especially if they were all these processes and procedures that are in the parole and post-release control revocation, they're really afforded everything you need to mount your own defense, to be represented, all the reasons for due process. So yes, that would really shore up all the holes. We would still be left with possibly substantive due process, separation of powers, and equal protection. But the procedural due process wouldn't really hold any weight anymore.
Let me ask you, ma'am, I'm sorry to interrupt you, but some of these cases, particularly Guyton, after a sentence was imposed by the trial judge, the issue was raised as the constitutionality. I think it was limited to the separation of powers. In the other cases, various aspects. Are we, or how are we permitted to consider all aspects of the constitutionality of Reagan-Tokes?
Sure. So when this came down the pipeline, and all of us foresaw these challenges coming, and I double-checked in our cases, we made sure that our attorneys and our panel attorneys challenged Reagan-Tokes and raised these issues in the trial courts. They were preserved. A lot of these cases are saying, well, it wasn't raised, too bad, so sad. So we made sure that they were preserved. And even in Mr. Mosley's case, where it's, last thing I'll say, sorry, the agreed sentence, is the agreed sentence statute provides that the agreed sentence can't be challenged so long as X, Y, Z, and the first thing is if it's authorized by law. And it would be our position that an unconstitutional statute is not authorized by law. So I'll reserve the remainder of my time. I see my time is up.
Thank you. All right, we will hear from the state panel.
Good morning, Your Honors.
Good morning.
First off, I really, with regard to the constitutional issues, I would submit that these are actually before the Ohio Supreme Court already, specifically O'Neill, which is the state's appeal in this matter. That decision was relied upon by the Cuyahoga County Trial Court, who also found the Reagan-Tokes law unconstitutional, and that was reversed by the 8th District, and now that issue is before the Ohio Supreme Court. So essentially, O'Neill was already before the Ohio Supreme Court, and it's the same issues. I would like to, with regard to the appeal in Guyton, it's the state's position that I don't know that the issue was preserved. If you look at the record, there was an agreed plea, and he accepted that plea and the agreed sentence with the indefinite sentence, and then did not challenge the constitutionality until after the sentence was imposed. So that is a nuance that the state wanted to point out with regard to that appeal. Just briefly, unless the court has any specific questions regarding the constitutional issues, I think it's important to keep in mind here with regard to due process, the procedural due process, and I think that that's been pointed out here a little bit. These are facial challenges that are occurring. Obviously, that kind of goes to, I know the rightness issue has already been decided, but what we have to look at with regard to the due process is not necessarily the future, but now. Was he afforded the procedural due process at the time that the sentence was imposed?
Well, no, I think the analysis is, does the statutory scheme in any implementing regulations provide defendants with procedural due process. And so I think, I guess my question is, does the state rely on this 105 PBD 15 in the context of its procedural due process argument?
Well, I think, again, procedural due process isn't going to involve a whole lot, especially at this stage. The procedure's we don't know how that's going to play out. We don't know if it will play out.
Well, but I think that's part of the problem that I think is underpinning a lot of the procedural due process challenges is you read the statute and you're like, well, what is the procedure here? How am I, as an inmate who's been sentenced under this scheme, and I have like a range from, say, 10 years to 14 years, how am I supposed to know? I've got a presumption in 10, but how am I supposed to know whether I get more than that?
Well, and again, I think that the guidance that's provided to this court in Woods is what we need to look to at this moment. I think some of these same issues with regard to post-release control, how that was going to play out. And that's why I think it's important with regard to the rightness issue, and that's how that played out is through a habeas process, because then we know how that procedure is being applied.
Through a what process?
A habeas.
Okay, so
that's how.
So to answer Judge Winkler's earlier question,
I believe so.
you could pursue habeas.
And I think that is the proper procedure because, I mean, we're trying to argue the nitty-gritty of this Ohio Administrative Code and these policies and stuff when we don't know, number one, if it's ever going to come to fruition.
But let's play that forward a little bit, because I think part of my concern, at least as you look at this policy, is there's not a whole lot in here, and there's no obligation for any sort of findings or even like a written decision or anything. So if the defendant says, hey, I had a 10 to 14 year term, I had a presumption in 10, they gave me 14 at this hearing, and they relied on stuff that was completely inappropriate, well, then we look at it on habeas, and there's no record, there's no transcript, there's no findings or anything, and then my presumption is the state would come back and say, well, presume regularity, et cetera. Like, how do we evaluate that on habeas?
Well, and I think we have, prior to the definite sentencing scheme that was provided in Senate Bill 2, we had an indefinite scheme in place before. This is a judicially imposed sentence within a range. So these
right, but the
distinction
is by the statutory presumption in favor of the low range.
Correct.
To me, that says the state has to do something to elevate it beyond the minimum. And then that's the question is, how do we evaluate that?
I don't think so. I think that if you look at this, I think that they're provided more procedural due process protections under this new indefinite scheme than were afforded under the old scheme. The presumption is in favor of the defendant. The state is not. I mean, it's really, and I think, and I don't know if it's in the transcripts in one of these, but one of the trial courts said it best, that this whole scheme is about you, the defendant. You have the power. You have the power over your sentence to show that.
That's right in a vacuum, but I think like one of the provisions is that you could be held longer if you've committed a violation of law that has not been charged. Okay?
It's within the DRC.
Right. But my point is, if I'm an inmate and I show up for this hearing and I have no notice as to what the basis is, and then I get at this hearing and whoever's prosecuting it says, oh, you committed this violation of law, you stole something from the commissary or whatever. And you say, well, that wasn't me. I didn't do that. Like, I know who did that. That was Bob. And not this Bob. But my point is, how are you supposed to like, how are you supposed to mount an effective defense if you get there and you're
Well, and
told this?
With all due respect, I think that that question points to exactly why the Department of Corrections is more the better body to make these determinations. If every little one of the day-to-day operations of a prison, if we
Yeah, we don't-
insert all of that.
No.
and then I think-
I understand that, and like but the way this scheme is set up, it gives DRC remarkable power to increase the length of this sentence within the range. And I think what I'm trying to understand is what procedural due process protections are there for an inmate who, like in my hypothetical, says, no, I'm being wrongfully accused of stealing something that I didn't steal, and so you shouldn't be able to hold me longer. But then they don't have any ability to mount an effective defense.
Well, and I don't think that we can look at the administrative code where the policies have been in place and make those determinations based on that. We simply don't know how that's going to play out procedurally yet. I don't know of anyone that's gone through the process, and that's why, we can look at two vacuums here. Your vacuum regarding, whether or not we can look at those procedures, based on how the state is going to reply, but also how they're going to be implemented by DRC. And I pointed that out in we don't even know if DRC's really going to mess with this much. It may be, we don't have, we don't know how it's going to how it's going to occur yet. We have that policy in place, but there's been no implementation of the policies.
Right, but
We have the administrative code.
but this is a facial challenge, so we have to evaluate what we have, and what we have is a statute, and we have this policy.
But what we have is a statute that provides for this sentence range. And I think that's this argument that we're having today points to, or is a good demonstration of how it's impractical at this moment for the court to review each one of those particular steps if indeed the sentencing ranges.
So then, like, if we agree with that, and so again, I'm an inmate and I go in for this hearing, and then I say, this is a violation of due process. Is my only mechanism of challenging it through habeas, or could I challenge it some other means if you're saying right now it's not ripe? Could I don't know, bring a delayed appeal? I haven't thought about this, but is there another way to do it other than through habeas?
I don't know if that's going, as far as the procedures that are set forth in the Ohio Administrative Code, and those are the parts, and I'm assuming when we talk about the policies, that's what's encompassed within the Ohio Administrative Code, that again, it's much like the former, where there the range was just the trial court implemented the range for that particular level of felony. And it was up to DRC to determine, okay, do you get, there was no presumption. Do you get out after serving the minimum range, somewhere in between? Here we have the procedure that's set forth is much more in detail than that was provided there. So I don't think, again, what we're looking at here procedurally is that range that was imposed by the trial court. And no matter what the defendant does, it can never go beyond that maximum part of the sentence that was. And I think that's the important, and I think that's why Woods is the most important decision for this court to rely on.
I had a question about the Woods case. I know it dealt with post-release control, but when the trial court notifies the defendant of the potential that he may be held longer than the low end of the range, is that part of the sentence? Because that's what, at least my reading of Woods, is that that's part of the sentence.
Correct. And that's very similar that we have here, because with post-release control too, remember we have mandatory aspects of post-release control as well as discretionary. So I think that, again, that was upheld in its entirety. So I think that this court need go no further than looking at Woods v. Taub with regard to the constitutionality of Reagan-Tokes. Unless there's any further questions, I think that's.
I don't have any more.
Great, thank you.
Much time's
Got like 8 minutes.
I only have a couple. Oh, good morning, Your Honor.
Because you only have 8 minutes.
Please,
You have 8 minutes.
I won't take much of that. I only wanted to address two issues, one specific to my case. I have the Mosley case, and it's with respect to the non-protunct entries that the trial court put on. The trial court sentenced Mosley to, there were 2 case numbers. In the first case number, he had 2 aggravated robberies with 2 specs. And then in the second one, he had an aggravated robbery and another spec. When you read the transcript of the sentencing, you'll see that defense counsel spells out exactly what was agreed upon, that Mr. Mosley was going to be sentenced to consecutive specs on the first case number, which is B20-00516, and then the 3 to 4.5 years for the aggravated robbery. The sentence for the other number, the 1228, was all of those were going to run concurrently. I think when the trial court, I don't know exactly why a nunc-pro-tunc was put on a month after the appeal was filed, but the trial court just kind of wiped out one of the consecutive specs.
Were those specs supposed to be consecutive pursuant to the mandatory nature of the revised code?
Yes.
Okay.
Yeah, and that was with respect to the first case number. So they're both 54-month specs, and so that's why what ended up happening when the court entered the nunc-pro-tunc order, it took off 54 months off his sentence. In Mr. Mosley's reply brief, counsel cites to a part that's quoted, but that part is the court referencing, that's on page 41. That's when the court's referencing the concurrent 3 to 4.5 years, which is the Reagan-Tokes part. So I just wanted to clarify that. And then the only other thing that I wanted to address, at least attached to the brief in the Mosley case, was a chart of portions of the law that would have to be excised, either in part or in toto. Obviously, the state argues that a Reagan-Tokes law is completely constitutional and no excision should take place. But at least in referring to that chart, 2 of the parts I think have nothing to do with Reagan-Tokes, and that's with respect to the statewide sexual assault kit tracking. When I read that part of the statute, there's nothing in there that refers to indefinite sentencing, so I don't see why that would have to be excised for any reason. And then also, and that's Revised Code 109.68, and then Revised Code 5120.53, the GPS monitoring survey. I don't think that has anything to do either with the indefinite sentencing. So if this court were to take the step and find this unconstitutional and list things that should be excised, those 2 definitely should be off the table. And unless you have any questions, I guess I'll save the rest.
You don't want to talk about procedural due process
I
anymore?
think you guys have covered it well, but
All right, yeah, thank you very much. Lucy, you have 10 minutes for rebuttal.
Okay, thank you, Your Honor. Regarding the constitutional arguments that are before the Ohio Supreme Court, State versus Hacker, the appellant's brief is not even due until June 13th, so it's going to be quite a while. And the other...
Do you expect that decision to come out before the end of the year?
No, I don't. No way.
Do you think it'll be argued this year?
Maybe.
Okay.
I haven't had a case up there for a little bit, so I haven't seen how far they are in scheduling. The last action in the other case where the constitutionality is State versus Simmons, the record was filed in April, and then nothing has happened on that since. So again, they're not going to get to this constitutional issue for quite a while. And let's see, 1, 2, 3, 4, 5 courts of appeals have not issued decisions, including this one addressing Reagan-Tokes constitutionality yet. I suspect that, they probably want to hear from as many as possible before issuing their decision.
Let me ask you that, the ones that have passed on the constitutionality, the seven sister districts have all found it, for various reasons, the Reagan-Stokes to be constitutional. Why should we go against that?
Aside from Delaval 2, the rest aren't doing this comprehensive analysis with the policies. So I think that is, I don't see how they at least surpass procedural due process without looking at the policies. So I'll respectfully disagree with their analyses that I think are too conclusory without looking at the whole picture. As far as counsel's argument that Reagan-Stokes was not properly preserved, I didn't bring the transcripts, but in Guyton, from what I recall, I believe it was raised at sentencing, and that was a plea. Counsel, I believe, misspoke. It wasn't an agreed sentence. It was a plea. Those are two totally different concepts. Mosley was an agreed sentence, so that's the argument that's a little bit closer. But the agreed sentence statute says the sentence must be not contrary to law in order to be, for the defendant not to be able to challenge it. And then O'Neill, the prosecution actually raised Reagan-Stokes at the hearing, and the trial court sua sponte struck Reagan-Stokes after consideration as unconstitutional. So if forfeiture or waiver wouldn't apply, that's when the trial court doesn't get a chance to weigh in upon an issue, and they clearly did. So as far as counsel's arguments regarding we don't know if or how the DRC is going to do this, those are ripeness arguments. That's already been decided firmly by Maddox. The issue remains whether the statute as written passes constitutional muster regardless of what DRC is going to do in the future, as the statute stands now. As far as saying that there are detailed procedures for Reagan-Stokes, I respectfully disagree. When you compare Policy 15 to, for example, the policy for parole revocation, which would be, I think that one's 9, it is. The Reagan-Stokes is 7 pages, the other one is 17. That's 10 pages of single-spaced additional procedure and process. That's a huge difference. And then regarding any errors in the Mosley nunc-pro-tunc, the state did not cross-appeal, so we would submit that those are not before this court at the time. It's not proper for this court to address them. And then regarding the chart, I did my best without having to read all hundreds of pages of legislation to say what would have to be done where. I can see that if it's a provision, and I tried to show that in my chart, that has, sometimes the legislation quickly sticks in other things. The legislature does it all at once. If the legislation doesn't have to do with Reagan-Stokes, like there is some monitoring, those would not have to be excised. It is really just the provisions that implement Reagan-Stokes. So if there are no further questions, I just ask this court to strike the law as unconstitutional and do its best to sort through what to excise.
All right.
Thank you.
Thank you very much. All right, Rapal?
Unless there's any further questions, the state doesn't.
Well, can I ask you a question about your prediction about the Ohio Supreme Court? Do you think that the case will be heard this year?
After consulting, we don't think it's likely.
Okay.
Do you mind?
Yeah, no, go ahead.
From past experience with the Supreme Court, I believe that in the Hacker case that the brief, they stipulated to an extension.
Mm-hmm.
I think it was maybe till June 13th for the appellant's brief to be filed. There'd be another, I don't know if it's 30 or 45 days, that would put them into mid-August, I believe, or August. And I believe given the campaigns and everything like that, my experience is that the court quits hearing cases like the first week of August.
Okay.
And it would be unlikely to hear any more.
Okay.
Because of quarterly changing.
Yeah. Thank you. That's very helpful. All right. Thank you all for your arguments this morning. We greatly appreciate it. Obviously, very difficult issues. And that wraps up our proceedings today before the First District. Hope everybody has a great day.